you care to just give Mr. Clark your permission to sign your name to the proposed consent judgment?
Yeah, I mean, he can do that.
I mean, sometimes it just seems easier if it's clear, it's on the record. If he added something, and he wouldn't do that, he's an officer of the court, that you didn't like, then you could say, hey, that wasn't part of the agreement. Do you understand that?
Yeah, I do.
All right. So
a convicted felon stands before the court facing serious firearms charges after authorities allegedly found an AR-15 pistol and an FN handgun in his possession. With multiple criminal allegations already on the table, this hearing could take unexpected turns. Stay tuned and subscribe for more dramatic courtroom breakdowns today.
All right. Midland Credit versus Jay Patel. 2505019. All right. Good. Your name, sir? Counsel?
Your Honor, would I have an opportunity to speak to Mr. Patel briefly?
Yeah, we can put you in a room. You want to go talk to the lawyer, see if you can resolve it?
Yeah, no problem.
Okay, so he'll take you to a place. Go right out in the hallway, and he'll set you up. They'll set you up on Zoom.
How many will give you the tablet?
Capital One versus Marcia Tong, 2505254.
Good morning, Your Honor. Dylan Clark, P88474, here on behalf of plaintiff.
Good morning, and I also have Capital. Oh, I see.
Yeah. I'm sorry,
Okay.
Gary. I'm trying to figure out how to unmute my phone. I apologize.
It's all right. Your appearance?
Gary Epps, P046306, subbing for Jeff Horowitz on behalf of Marcia Tong.
I think I'm going to need some more pictures, but I got a couple right here. Okay. Any resolution on this, gentlemen?
Your Honor, I didn't have a chance to speak to opposing counsel yet. However, if Gary isn't against doing so, 60 days discovery and a scheduling order would be great.
Yeah, sir, I have no settlement authority beyond what might have already been conveyed to Dylan, so that would be fine with me.
All right, let's do this. Today is the 21st. Just give me 1 sec. All right, I'll give you until we'll call it May 21 for this. I'm sorry, June 21 for discovery. No motions will be heard on the date of trial. All motions for summary disposition have to be filed and heard not later than 20 days before the trial date. There will be no ADR. Nobody demanded a jury, correct?
Correct, sir.
No settlement conference. I'm putting down 1/2 hour. Witness lists are due by May the 21st. You do not have to file a trial brief. If you choose to file one, it has to be filed and exchanged not later than 7 days before the trial. I will that's it. We're going to give you the trial date right now, Jennifer. You have one for me, say in the latter part of July, early August.
July 27th at 10:30.
July 27th at 10:30. Okay.
Yes.
Very good. Thank you, Your
Looks
Honor.
like I'm back here at 10 o'clock too, so thank you, everybody.
Okay. Thanks, Mr. Apps. Anything else, Mr. Clark?
Nothing further in this matter, Your Honor. I was speaking to a defendant in the breakout room for Capital One v. Barry. We are ready for that. We have a resolution.
You have a resolution?
We do, yes. I believe that she is in the breakout room still, though.
I see her right there.
No,
June.
there she is.
Here, I'm going to just hand you these, Sadie. Capital One versus Tina Berry, 2600065. Your name, ma'am?
Tina Berry.
Counsel?
Dylan Clark, P88474, here on behalf of plaintiff.
All right, so you said you have a resolution. What are the terms?
Your Honor, Ms. Berry has agreed to make monthly payments of $124 towards a total judgment amount of $2,973.66.
Get a little closer to that device or turn it up, will you please? 2973, she's going to pay 124 per month?
Yes, $2,973.66, Your Honor. That consists of damages in the amount of $2,848.31 and court costs in the amount of $125.35. First date of payment will be May 1st, 2026, continuing on the first of each month thereafter until the balance is paid in full. And Ms. Berry has provided me her email address so I can forward her the consent judgment along with payment instructions for her review.
Ma'am, Do you understand everything that Mr. Clark just said?
Yes,
So he's telling me you guys are, and this is going to be in the form of a consent judgment, correct, Mr. Clark?
Correct, Your Honor.
So ma'am, do you understand if you consent to this, there would be a judgment entered in favor of the plaintiff, capital one, against yourself. It would call for damages in the amount of $297,366 with a further provision that you have to pay $124 per month beginning May the 1st of 26 and the first of every month thereafter until paid in full. Do you understand that?
yes, I do.
And you agree to that?
Yes,
And so long as you do that, the plaintiff cannot garnish wages. They could still garnish bank accounts, they could garnish tax returns, but no wages. Do you understand that?
yes,
Can we short circuit this? And we could, if you want, you care to just give Mr. Clark your permission to sign your name to the proposed consent judgment?
yeah, that, I mean, he can do that.
I mean, sometimes it just seems easier if it's clear, it's on the record. If he added something, and he wouldn't do that, he's an officer of the court, that you didn't like, then you could say, hey, that wasn't part of the agreement. Do you understand that?
Yeah, I do.
All right, so he has your permission to sign your name to the proposed consent judgment?
Yes,
Okay, you are all set. I wish you well. Thank you both. Have a good day.
Thank you, Your
thank
Honor.
you. You too.
Velocity Investments versus Jeffrey Dillon, 2600385.
Good morning, Your Honor. Angelina Abufarha, P number 88197 on behalf of plaintiff.
Okay, is the defendant here?
Yes, I'm here.
Okay, I'm sorry, Mr. Dillon, your name?
Jeffrey Dillon.
All right, just give me 1 second, please. Any resolution on this one, counsel?
Not yet, Your Honor. We did enter settlement negotiations, so we could have a potential resolution shortly.
Okay. And your P number is 88197, right?
Correct, yes.
The bond debate reaches a critical moment. Prosecutors point to prior firearm-related convictions, arguing that history matters when assessing risk. The judge ultimately agrees with the state's concerns and imposes a $10,000 bond. Do you think the court made the right call, or should the amount have been lower?
All right, so you guys just want dates? Do you need discovery?
Dates are great. You can open discovery just in case. I know plaintiff, we don't really send out discovery, but in case a defendant would like to.
June 21, you have to conduct discovery by. Discovery is the exchange of information, Mr. Dillon. So if you wanted something, documents or what have you, or you wanted to send them interrogatories, you have the right to do that. You have to file a witness list in this case by May the 21 of 26. Witness list due June the 21 of 26. You don't have to file a trial brief. If you choose to, you have to file and exchange it not later than 7 days before the trial date. No motions will be heard on the day of the trial. All motions for summary disposition have to be filed and heard not later than 20 days before the trial date. Still July 27th at, would you say 10:30, Jen?
Yes, Your Honor.
So I'll set the trial date for July 27th at 10:30. You should have this very shortly. Do you have to bring up anything else, Ms. Abufarah?
No, Your Honor. Thank you.
All right. Mr. Dillon, anything else?
No, sir.
Have a great day, you two. Thank you very much.
Thank
Thank
you
you.
as well.
Do I have anything else down there?
Judge, I do have Miss Brown back in. I'm not sure if
Oh, you have
Mr.
Is that on
Patel is going to
Midland
come back
versus
into.
Patel?
Yeah, I'm not sure if he's going to come back. There he is. He's back in the courtroom now.
All right, Midland Credit versus J. Patel, 2505019. Everybody's name, please.
Adrian Brown, PA 3947 on behalf of Midland.
All right, any resolution?
We have a resolution, Your Honor. We have come up with a consent judgment. We have damages totaled at $2,905.53 to be paid $300 per month starting May 15th until the balance is satisfied. And Mr. Patel would prefer for me to send a copy for his review for him to sign, and then I can submit it to the court once it's returned to me.
You
If that's
understand and agree to those terms, Mr. Patel?
Yes, I did.
So you are agreeing by this that the amount of 2,905.53 is owed, and you agree to pay $300 per month beginning May the 15th of 26.
Yes.
All right, so I'm going to go ahead and wait for the judgment. Jennifer, we're going to reset the pretrial in case I don't have it by then. So we'll reset the pretrial for May the
18th?
No, before the 15th, I want to do it. So let's set
Okay.
it for May the 12th or thereabouts.
We can do May 11th. It's your probation day, but it would be one simple pretrial. So
At
we can do
8:30.
that at 8:30.
So we'll reset the pretrial, assuming I get everything. You have to show up unless you get the judgment back signed by me before then, Mr. Patel, okay?
Can you explain that again?
Yeah, because I need to have, there has to be a control date. She's going to send it to you.
Okay. Is that the signature that I have to sign?
Correct.
Okay.
And you're going to send it back.
Mhm.
And I can't just let this case sit out there because sometimes people don't do that. So I'm going to reschedule this for May the 11th at 8:30.
Okay.
If you don't have to show up, so long as you forwarded the proposed judgment to her, she sent it to me and I've signed it and you have a copy. So they'll send you a copy once I've signed it down the hall. Okay?
No problem, sir.
All right. Do you understand?
Mhm.
Okay. You're all set. Thank you.
Thank
Thanks,
you, Your
Ms.
Honor.
Brown. Do you have any others or not?
I believe that's all. Thank you so much.
Have a great day. Thank you.
You take care.
All right. What do I have now here? Is it LVNV versus Hancock?
Judge, I don't have defense attorney there, but plaintiff's counsel's in the breakout room. I have the 9 o'clock Velocity versus Shelley is ready. Both parties have spoken.
You have that one. Thank you. Velocity Investments LLC versus Kelly R. Shelley, 2600675.
Good morning, Your Honor. Michael Bengstein, P697778 on behalf of Velocity Investments.
Ma'am, your name?
Kelly Shelley.
Have you two talked?
We have, Your Honor. We've exchanged phone numbers and email addresses. We did talk about payment arrangement or settlement, but we don't have a deal at this time, Your Honor. We need to put some dates on the calendar.
69778. Let's see, ma'am. I'm going to go ahead and ask you. All right. First of all, I'll be glad to give you guys discovery. Discovery cutoff is June 21st. No motions will be heard on the date of trial. All motions have to be filed and heard not later than 20 days before the trial date. Nobody demanded a jury trial, correct?
That's
You
correct, Your Honor.
And you didn't either, correct, ma'am?
No, Your Honor.
All right. So witness lists are due May 21. Discovery cutoff, which is the exchange of information, ma'am. If you want something from them that you think will help you defend the case, then you're free to request it in writing from them. You're free to send them interrogatories. Witness list due May 21, discovery cutoff June 21. Pleadings are in order.
Now, the focus shifts to a domestic violence case, and the defendant makes an emotional appeal. He tells the court he supports 5 young children and wants that considered during bond decisions. The judge carefully weighs family responsibilities against serious allegations, creating a tense and unpredictable courtroom moment.
And your trial date again will be July the 27th, and that will be at 10:30 in the morning. July 27th at 10:30 in the morning. Okay? Is there anything else anybody needs to bring up here?
No, Your Honor. It sounds like 7/27 at 10:30 a.m. bench trial, June 21st discovery cutoff, May 21st witness list and exhibit list. All motions now filed and heard no later than 20 days before trial, Your Honor.
Correct.
Okay. Thank you, Your Honor. I don't have anything further.
All right, you guys are all set. Have a great day. Any questions from you, Ms. Shelley?
No, Your Honor. Thank you.
Thank you very much. LVNV versus Brian Hancock, 2600624.
Your Honor, Mr. Strauss just checked in and he's in with counsel on that one.
Yep, another.
The two cases that,
Acceptance
oh,
versus Amy
they're
Tank.
coming out now.
Is Amy Tank out there?
She is not yet.
LVNV versus Brian Hancock, 2600624.
Good morning, Your Honor. Oh, I'm sorry. Good morning, Your Honor. Frank Price, PA 2598 on behalf of plaintiff.
And Gary Strauss on behalf of defendant, 48673.
All right, just give me 1 second.
Sure.
82598, right, counsel?
That is correct.
All right, good enough. No resolution?
No resolution at this time. If we could just ask for 60 days of discovery and we will continue settlement negotiations.
No motions will be heard on the date of trial. All motions for summary have to be filed and heard not later than 20 days before the trial date. Discovery cutoff will be June 21. Witness lists are due May the 21. You don't have to file a trial brief. If you choose to file one, you have to file and exchange it not later than 7 days before the trial date. July 27 will be the settlement conference. I'm sorry, the bench trial date, and that will be at 10:30 in the morning. Okay.
All right. Sounds good.
Anything else anybody needs to bring up?
Nothing for plaintiff.
No.
All right. Have a great day, gentlemen. Thank you very much.
Thank you.
I have a couple more with you. Well, actually, yeah, several more, but 2 more in the 9 o'clock.
Which one's that?
One might be on the off the docket already. Barbara Johnson, 00150. We had a consent judgment filed Friday.
That we did get that consent already, Judge,
Okay.
so that one is off.
And then the other one is JP Morgan versus Ned 2600662, Attorney Cruz and I.
Do you have JP Morgan? Do you have those?
I gave them to you.
Do you have any more?
I gave you that left it up.
Oh, wait a minute.
Yeah. Oh.
JP Morgan, my apologies. JP Morgan Chase versus Tiffany Ned, 2600662. Okay, appearances.
Good morning again, Your Honor. It's Frank Price, and that's P82598 on behalf of plaintiff.
And for the defendant, Trevor Cruz, P73401.
Guys, just give me 1 second here, okay?
All right.
Okay, so I have 82598. How high are the P numbers? Is anybody at 90 yet?
I don't know if I've seen a 9 yet.
Yeah, I can't say that I have. Probably getting close, though.
73. Yeah, I know. It's crazy. June 21 is discovery. So no resolution, right?
Yeah, not at this time.
That's fine. All right, so here's what I'm going to do. Witness lists are due on May the 21st of 26. Witness lists due May 21 of 26. Nobody demanded a jury, correct?
Correct.
Correct.
All right, so we're not going to have a settlement conference. I'm putting down 1/2 hour for trial. Discovery cutoff June 21, no ADR, none of this. And then I'm going to simply set the trial date for July the 27th, at 10:30 in the morning. And again, all motions for summary have to be filed and heard not later than 20 days before the trial. Okay. I think that covers it unless somebody has something else.
No, sounds good. Nothing for plaintiff.
Nothing for
Pardon?
defendant.
Okay. Thank you very much. Have a great day, gentlemen. Thank you.
Back at 10, actually. Have a good one.
Credit acceptance versus Amy Tank. Credit acceptance versus Amy Tank. 2504669.
Judge, if I may, I've got someone that just logged in on an iPhone. If I can get their name, please, if they unmute.
Phone, we need your name, please. Can you tell us who you are?
Good morning, Your Honor. My name is Cortina Thomas.
Sorry.
Okay, you have to start your video and put your name on there, would you please? So we
Judge,
know
I'll
who
add
you
her
are.
name.
Okay,
Thank you.
all right. So is anybody here on credit acceptance versus Tank?
The plaintiff's attorney is, I'm letting him in now. And the defendant has not checked in yet.
Mr. Begg, I'm ready to go, but I gotta wait 15 minutes. So I'm gonna give them till 15 after. If they're not here, I'll call it and I'll default, okay?
In the meantime, I'm gonna put Mr. Bagg in with Miss Thomas. He's on that case.
Okay, that's fine. John, give me everything else, will you please? Okay. People against Jamie Antonia Williams Bay, 23W831-736.
The hearing concludes with a decision that blends accountability and supervision. The judge orders a reduced bond but adds strict conditions, including GPS monitoring, alcohol restrictions, and no contact with the alleged victim. Those conditions will shape everything moving forward. Like, comment, and subscribe for more shocking courtroom stories.